Okay, thank you all. Okay, so unfortunately, Rabia Belt was supposed to be the commentator and was going to be introducing them. Something unexpected came up in the last minute, and sadly, she was unable to be with us. So I will do the introductions, and then we'll have a bit more time for conversation since we don't have a kind of formal comment prepared. I think I have your names here in alphabetical order, but I don't know if that's the order you guys want to go in. Or...
I think Laura's going to go first.
Either? Okay.
I'm not.
Okay.
I wasn't prepared for that decision.
Okay, so Laura Munoz is an assistant professor of history and ethnic studies at the University of Nebraska-Lincoln. She previously worked at Texas A&M, a University Corpus Christi, Hispanic and minority serving institution in her hometown. She's a former National Academy of Education Spencer Postdoctoral Fellow and a recent recipient of the AHA's Gilbert Award for the Best Article on Teaching History for her essay, Civil Rights, Educational Inequality, and Transnational Takes on U.S. History, on the U.S. History Survey, which is published in the History of Education Quarterly. She earned her undergrad degree at the University of Texas, Austin, and her PhD from Arizona State. Penn Press recently published her book, Desert Dreams, Mexican Arizona and the Politics of Educational Equality. In Desert Dreams, she details how Mexican-American families embraced education as a pathway to sustain citizenship, political engagement, and cultural preservation in the late 19th and 20th centuries. I will just, I will read, and then you guys will decide what order. So, Will Holub-Moorman, am I pronouncing it right? Okay, Will Holub-Moorman is a PhD JD candidate at Princeton, of course in history, and also, two schools, right, of course, Princeton, and the University of Penn Law School. His dissertation project traces how welfare administration intersected with efforts to redefine and police parenthood's legal obligations in the late 20th century US. Will has also been a digital fellow at the Society for the History of Children and Youth since 2021. And last but not least, Doris Morgan Rueda is a legal historian who studies the intersection of juvenile justice, the Latinx experience, and the American borderlands. She received her doctorates at University of Nevada, Las Vegas, before coming to Stanford Law as our Law and History Fellow. Her research focuses on the development of juvenile justice systems in the American Southwest through the policing and incarceration of Latinx youth. Her current project is a book on the history of juvenile justice in the borderlands and an article on the use of narrative and newsletters by youth incarcerated in Arizona's Fort Grant Industrial School in the early 20th century.
Thank you. The national practice of Mexican-American school segregation. In March 2024, Dr. Manuel Espinosa and his students at the Right to Learn Dignity Lab in Denver proposed an educational amendment to the Colorado State Constitution calling for the legal recognition of education as a fundamental right. The amendment expands the original call for free education of all residents by defining education as a human right, quote, necessary for the fulfillment of freedom, justice, and peace. Espinosa links his work as an ethnographer of education to his personal history as a child of desegregation and to the 1973 landmark Supreme Court case, Keys versus School District No. 1, which ordered the city of Denver to integrate its public schools. Denver had, as the court viewed it, intentionally implemented a tri-ethnic segregation policy for its black, brown, and white students. In the Supreme Court opinion, Justice Brennan wrote, quote, Negroes and Hispanos in Denver suffer identical discrimination in treatment when compared with the treatment afforded Anglo students. He reminded the district court that Hispanos constitute an identifiable class for purposes of the 14th Amendment, citing the holding in Hernandez versus Texas, 1954, and also 4 additional school desegregation cases involving Mexican American and African American students. While Keys is one of the few desegregation cases that the U.S. Supreme Court has decided, it is emblematic of the many cases around the nation that attempted to resolve the question of Mexican American school segregation before and after Brown v. Board of Education. Since the early 1900s, people of Mexican heritage living and working in the United States who possessed U.S. and/or Mexican citizenship have challenged the educational segregation of their children in local, state, and federal courts and through diplomatic relations between the Mexican consulate and the U.S. Department of State. The purpose of this paper is to reconsider the scope of this Mexican-American school segregation and to posit its existence as a national project of de jure segregation. Often the historiography and case law have focused narrowly on the specific incidents of segregation, such as Mendez versus Westminster in California that generated the first federal holding for desegregation, or Cisneros versus Corpus Christi Independent School District that extended minority status to Mexican Americans and subsequently to all Latinxes. Considering these incidents individually, however, has led us to believe that Mexican American school segregation took place during isolated moments in specific towns or states or along the U.S.-Mexican border. Such characterization has deterred us from examining the full geographical scope and legal rationales for Mexican-American educational segregation and the ways that it has played out in our communities across the United States and as a national project of racial discrimination and subordination. I argue that while no specific law intentionally called for the segregation of Mexican-American children, the consistency and comprehensiveness of Mexican-American school segregation existed in the spirit of Jim Crow. The breadth and depth of Mexican schools, as they came to be known across the continental United States, and the case law that emerged from challenges to this, relied upon the holding of Plessy v. Ferguson and validated separate but equal education for Mexican-American youth. These findings subsequently legalized the practice of Mexican-American school segregation across the nation and allowed the state as public authority to build an infrastructure that supported it and financed it on the basis of race, as well as the common justification of language. The existence of Mexican schools as they also signaled the overall nature of racial segregation in local American communities. If a Mexican school existed in a town, so too did residential, labor, and economic segregation, as well as political subordination. The Mexican school and variations of it, such as separate classrooms for Spanish-speaking children, became a status quo symbol of American segregation and white racial authority. I propose that we reconsider the different ways that Mexican schools might fit within the scope of de jure segregation as a state-supported model of separate but equal education. I examine this question through three strands: the relationship of Plessy v. Ferguson to Mexican-American school segregation, the notion of public authority, and the role of the state as a factor in allowing, sustaining, and enforcing such segregation, and the role of the state and federal governments both in funding segregated Mexican schools and in negotiating diplomatic relations between Mexico and the United States in matters of school segregation. Since the 1970s, Latinx historians have slowly and painstakingly documented over 40 legal challenges to Mexican-American school segregation across the nation. This recuperative history grew out of the Chicano civil rights movement and important moments such as the spring 1968 Los Angeles high school blowouts, when thousands of Chicanx and Latinx youth walked out of their high schools to protest the inequity and discrimination they experienced in the LA public schools. As scholars documented this educational inequity, they uncovered dozens of school segregation cases that range from the 1910s to the 1980s. As historian Peter Lau explains in his edited collection, From Grassroots to the Supreme Court, bottom-up histories have almost always privileged the local over the national, the social over the institutional, and the particular over the representative in their examination of struggles for civil rights and freedom. Now, at this juncture, with hindsight and with a catalog of 40-plus cases, and 100 years of case law examining the question of Mexican-American school segregation across the U.S., scholars can begin to flip the analysis by privileging the national, institutional, and representative patterns in order to understand the cumulative implications of Mexican-American school segregation as a project of American governance. To understand the racialization of Mexican Americans as non-white people, you should keep in mind the Mexican-American War of 1848, Since then, Anglo-Americans have questioned where Mexicans belong in our nation and on the race spectrum. In that war, the Mexican government ceded over half of its nation to the United States. The outcome of the Treaty of Guadalupe Hidalgo itself skirted around issues of race and color, focusing instead on nationality, forcing Mexican citizens in the ceded territories to choose their allegiance and in many cases to forfeit their land holdings. The treaty also significantly included clauses, Article 9 in particular, that extended the citizenship of, quote, white men to Mexican men in the forfeited territories. Legal scholar Ian Haney Lopez explains this, quote, white by law construction by delineating how racial prerequisite cases cataloged Mexican-American racial identity, including the 1897 Inri Rodriguez case, which extended citizenship and constitutional rights to all Mexicans in the ceded territories. Such legal declarations fell by the wayside, however, as the social and political constructions of American race relations prevailed in the aftermath of both the Mexican-American War and the U.S. Civil War. The Jim Crow system of American apartheid cemented itself across the South and into the West as Anglo-Americans moved into new territories. As historian Vicky Ruiz recounts, the codification of school segregation in the Western United States came early. In 1852, 2 years after California became a state, the legislature passed a bill barring African American children from schools. By the early 1870s, California opened its first segregated school in the town of Visalia. School officials paid African American teacher Daniel Scott a small fee to teach both Mexican and Black children who'd been denied admission to the local public school. Even though in California and across most of the United States, African American school segregation was the only one codified by law and reinforced in court, Anglo-Americans used this legal framework to establish practices and procedures, to develop variations of school segregation for children of Mexican, Black, Asian, and Native American heritage too. The first reference to separate but equal as an educational practice appeared in the 1872 California case, Ward v. Flood, in 1873, which was filed by an African American mother in San Francisco whose daughter had been denied admittance to an all-white school. This ruling paved the way for school leaders to begin a process of governance that allowed for the structural segregation of non-white children across the West. Historians David G. Garcia and Gonzalo Guzman describe how, quote, the local elite and everyday white people, civic and business leaders, teachers, parents, homeowners, use schools as the architects of race. In my work on the history of Latinx education in Arizona, I explain how school leaders constructed school segregation as a racial logic that mirrored the separate but equal standard of Plessy v. Ferguson and the color of law validations of later desegregation cases. The general legal explanation of Mexican American school segregation has been that it is de facto segregation based on social custom and classified not by race, but for some other child-oriented teaching solution, such as learning to speak English. However, since the early 20th century, eyewitnesses have challenged this view. In 1917, the U.S. Bureau of Education interpreted the scenario in Arizona as intentional racial segregation. Quote, we do not have any data showing the number of years the Mexican children are kept separate from the American children. The segregation is presumably not for racial reasons, though it is no doubt for this reason. I'd like to turn to the three different strands I mentioned earlier and discuss how specific legal cases and/or state and federal intervention specifically governed Mexican schools. The relationship of Plessy v. Ferguson to Mexican American school segregation. Since Plessy, courts and communities have argued about the distance between de facto and de jure segregation. Some scholars believe that Mexican American school segregation should be characterized as a matter of de jure segregation, even though no specific law authorized the segregation of Mexican American students. Historians Ruben Donato and Jared Hansen describe this segregation as, quote, the other American dilemma, a play on Professor Gunnar Myrdal's 1944 American Race Relations study entitled An American Dilemma, The Negro Problem in Modern Democracy. Donato and Hansen argue that Mexican school segregation as a project included the same intent and outcome as Jim Crow, or what some callers, including myself, now identify as Juan Crow, or the systematic exclusion of Mexican heritage people from American society. Donato and Hansen redefined de jure segregation to include any government action that results in the segregation of students based on race, regardless of whether that policy is a law mandating segregation at the state level or a decision by local school officials that facilitates racial segregation. They also argue that de jure segregation occurs whether or not the rationale is explicitly racial. Donato and Hansen essentially say that actions of the governing bodies in denying Mexican American students equal protection and due process enacted de jure segregation. The earliest cases on Mexican American school segregation do invoke the Plessy standard. This in and of itself might be valid enough reasoning to consider Mexican schools as a form of de jure segregation. The Plessy standard is cited as one way to enforce and to sustain Mexican school segregation. If districts wanted to segregate Mexican children, then they had to prove that they provided separate but equal access and accommodation. If they did not meet the standard, then integration might be a requirement. To date, the earliest known Mexican school desegregation case is Maestas v. Schoen, filed in 1913 by Mexican American parents against the Alamosa, Colorado School District. In this case, the school district's defense attorneys argued that their Mexican school met the Plessy standard. The Mexican school facility was, quote, one of the best in the city, sanitary, and that the equipment is equal to, if not superior to, any school building. In the Arizona case of Romo v. Laird, 1925, the plaintiffs framed their case around Plessy to demand equal access. The Mexican American parents argued that their children did not receive an equal education because the segregated school was taught by student teachers, that is, non-certified apprentice teachers who were assigned to the Mexican school to complete a course in practice teaching in order to earn their college degrees. The Superior Court agreed that the school district had to fulfill the Plessy standard if it planned to continue segregation on, quote, race lines. Later, the district's inability to meet the Plessy standard created an opening for some Mexican American children to enroll in the American or white school, but the district soon adjusted itself, and the Mexican school segregation remained in place until World War II. The Superior Court's interpretation of Plessy stemmed from the Arizona Supreme Court verdict in Dameron v. Bayless, an African American desegregation challenge. The Bayless family sued the Phoenix Public Schools because their children had to cross railroad tracks to access the Negro school, which they argued prevented safe and equal access to the school. The Arizona Supreme Court denied the Bayless family, ruling that it was only upon arrival at the school building that the Plessy standard could be invoked. The court wrote, "It is only after children arrive at the school building that it be as good a building and as well equipped and furnished and presided over by as efficient a corps of teachers as school provided by children of other races." This line of reasoning subsequently shaped the Romo verdict. Mexican children, just as black and white children, could be segregated in separate schools as long as they were taught by an efficient corps of teachers. To emphasize this point, Judge Joseph Jenks quoted Bayless directly. Quote, "The language employed by our Arizona Supreme Court is equally applicable to the Mexican situation presented here in Romo." The first 6 cases of known Mexican American school segregation cite Plessy as a rationale for maintaining schools. To give you a better sense of this link that white Southerners made between Mexicans and African Americans, consider the Cheneyville, Louisiana incident. In 1915, a white school trustee ejected 4 Mexican children from the white school. The trustee's father turned out to be the same man who purchased Solomon Northup, a free black man known for his memoir, 12 Years a Slave. 2, the notion of public authority and the role of the state as a factor in allowing and sustaining and enforcing such segregation. Public authority refers to the institutional actors. In matters of school segregation, these authorities include school leaders, school boards, school districts, and state departments of education, all of whom are vested by public school codes to make decisions and write policy to fulfill their duties. Most school administrators took these duties seriously. In some cases, school leaders sought legal counsel to understand the scope of school law. For example, in 1915, in Cheneyville, the county school superintendent confirmed with the district attorney that no law barred Mexican children from attending the white school. But Jim Crow segregation prevailed anyway, and the Mexican families soon disappeared from the local community and the public record. In Arizona, school administrators often wrote the Attorney General for guidance. 10 years before Romo, the Arizona Attorney General confirmed that it was illegal to segregate Mexican children. He wrote, quote, "Our law empowers the trustees to segregate children of the African race, but does not empower them to segregate children of the Mexican race, unless, of course, children of the Mexican race might also be of African descent by being intermingled with African blood through birth." Just as in Louisiana, Arizona school trustees ignored the Attorney General's interpretation in favor of local action and turned instead to the expertise of educators and scholars. In 1923, in the town of Miami, Arizona, town leaders convinced the local copper mining company to finance a $125,000 new state-of-the-art vocational school. The new Bullion Plaza School, named for the copper bullion the mine produced, trained the Mexican and Apache children of its mine, mill, and smelter employees. Bullion Plaza operated as a segregated school until 1951. The Miami school superintendent, Charles Tupper, graduated from Stanford University and was a protege of the renowned IQ expert Louis Terman. Tupper explained, "When it is recalled that the children of Mexican laborers in the mines of the district almost invariably drop out after the 6th year to take up unskilled manual labor or to set up a home of their own, it will be readily appreciated that the schools owe it to these children to provide them with definite training in this direction. In place of condemning them to failure, discouragement, and early elimination by confining their school training to the traditional course of study looking toward high school entrance and graduation." 3. The role of states and federal governments both in funding segregated Mexican schools and in negotiating diplomatic relations between Mexico and the U.S. in matters of school segregation. State and federal political officials also took up the question of Mexican-American school segregation. At the state level, the Romo case offers an example of how the legislature and higher education leaders reinforced Juan Crow segregation. When Arizona applied for statehood in 1910, legislators had to write a new constitution. They recruited the president of Arizona State Teachers College to draft the new school laws, including provisions for segregating African American children. However, the final draft, which was adopted as the 1913 Civil Code, expanded the segregation rules to allow school boards to segregate, quote, "any group of pupils they deemed advisable." This created lawful openings for strengthening both Jim Crow and Juan Crow. At the federal level, the nation supported Juan Crow in two specific ways. During the Great Depression, the Work Progress Administration financed new school buildings, including segregated Mexican schools, and the U.S. Department of State mediated conflicts with the government of Mexico over segregation that affected the children of Mexican citizens. In Worland, Wyoming, school officials received state and federal funding for the Columbia School for Spanish-Speaking Children of Agricultural Workers. The school district won funding from both the Public Works Administration and the Works Progress Administration to build a new school so that, quote, "the Mexican children may be segregated from the white children." In Glendale, Arizona, the WPA also financed the new Mexican grammar school for, quote, "several hundred children of Mexican and Spanish American parentage." Of course, ironically, at the same time that the New Deal funded these schools, state and federal officials had also engaged in the forced deportation and repatriation of Mexican people in what is known as the Decade of Betrayal, where anywhere between 500,000 to 1 million Mexicans, U.S. citizens, and Mexican citizens were forcibly deported from the United States. Government officials from the United States and Mexico also documented and mediated many different ways and places that Mexican schools emerged in the 20th century. As early as 1911, Mexican consuls in Texas received complaints of school segregation. The New Orleans Mexican consul, for example, was responsible for bringing the Cheneyville, Louisiana incident to light. School leaders wrote a series of letters confirming the nature of Mexican segregation in their town, and the New Orleans consulate preserved copies of those letters in their official reports to the Mexican ambassador. In Kansas City, Missouri, the Mexican consul negotiated a dispute between white parents and the Santa Fe Railroad Company, who brought Mexican laborers and their families into that town. The white parents wanted the Mexican children segregated, and the consul agreed to separate 125 children in a new school. In 1931, California, the Mexican consul in San Diego helped Mexican parents file the lawsuit that came to be known as Alvarez versus Lemon Grove. In conclusion, scholarship on the history of Mexican American education has not yet fully addressed the breadth and scale of Mexican American school segregation across the nation. However, by privileging the national, institutional, and representative, as I've attempted to do here today, we can begin the process of mapping Latinx educational segregation as an American phenomenon. Whether Juan Crow segregation is seen as de facto or de jure, it is clear that segregation functioned as an organizational ideal of American governance that shaped educational practices that intentionally underserved generations of Mexican American youth. You want me to sit up for you?
Sit up.
Yeah, I'll sit up.
Maybe we need to enable it.
Yeah, I'm trying to.
Oh, that's it. Thank you. Okay, so the title of my talk today is Tough Love, Child Support Enforcement, Welfare Reform in the U.S. Administrative State, 1970 to 2000. In 1996, the Los Angeles District Attorney's Office informed Peter K. that he owed them $23,000 in unpaid child support. Now, abbreviating Peter's last name, and we'll be referring to him by his first name to protect his privacy. A 60-year-old resident of Ventura County, then making $5,000 a year, Peter was the father of 2 daughters. But given that his daughters were now in their 30s, he was confused about why he was being asked to pay now. Upon contacting the LADA's office, Peter learned that the money would not go to his children. Instead, it would go to Los Angeles County, the California Department of Social Services, and the federal government to cover the cost of welfare payments issued to his ex-wife in the 1970s when he was not providing financial support to his daughters, plus 20 years of interest. The county's new computer system had automatically matched Peter's employment records from the 1990s with his family's welfare case from the 1970s and calculated his bill. The LADA's office then requested that Ventura County garnish $100 Peter's monthly wages. In the late 1990s, Peter spoke despairingly about his situation. There seems to be no way out, he said. Violent criminals serve their time when they get out and start a new life. For me, there is no hope to start a new life. There is no hope that I can ever pay off my debt. A spokesperson from the LADA's office had a different take. It's just a matter of the system finally catching up with him. Now, I wanted to start off today by describing Peter's case for a couple of reasons. First, it encapsulates both in time frame and subject matter what I'm going to be talking about today, which is about how between the 1970s and 1990s, California counties expanded and systematized the collection of child support through methods of interagency and intergovernmental collaboration. My talk today is based on research completed at several archives in California, including the records of the Department of Social Services at the State Archives in Sacramento, the papers of LA County supervisors and district attorneys held by the Huntington Library, and the Reagan Library and the Hoover Institution right around the corner. But Peter's case also serves as a reminder that the historical processes and institutions I'll be discussing were navigated by real people and often dramatically affected both their everyday lives and sense of legal standing vis-a-vis the state. And I should say there's a whole realm of past and ongoing debate among feminists, legal scholars, policymakers, and advocacy groups about the child support enforcement system that emerged in late 20th century America, whether it benefits children, whether it reinforces or undercuts gender-based inequalities, whether it is racially discriminatory, and whether it crowds out more just possibilities for social provision. Most of that is beyond the scope of my talk, But I wanted to acknowledge that if you felt conflicted about Peter's story, you're in good company. There's a lively debate about whether stories of Peter, like that of Peter, represent injustice or a necessary outgrowth of a system that takes parents' responsibilities to their children seriously. According to one recent study, 30% of the United States' adult population has either paid child support or been its legally designated recipient. So that means that support orders represent far and away the most common civil judgment in our country. And perhaps that sheer scope is why historians have largely not delved into the administrative structures and law of late 20th century support enforcement. We know much more about family desertion in the early 20th century, thanks to work by scholars such as Michael Woolrich, Anna Igra, and Elizabeth Katz, who have detailed the emergence of local family courts and their use of criminal probation against deserting spouses, but more importantly, the persistent difficulties in enforcing support orders in an increasingly mobile society. Legal historians such as Deborah Dinner, Alison Lefkowitz, Serena Mayeri, and Suzanne Kahn have examined political campaigns for and against tougher support enforcement by feminists and fathers' rights groups, which were happening while in the midst of divorce and custody reform between the 1960s and 1980s. And finally, books by Melinda Cooper, Anna Marie Smith, and Marisa Chappelle have all pointed to the ideological significance of child support to the neoliberal and conservative political coalitions seeking to impose welfare austerity in late 20th century America. But we're still missing a sustained account of how child support enforcement came to work and not work in practice as a system that bridged county, state, and federal governments, as well as public and private institutions, as well as the mix of laws and informal policies that governed its operation. Understanding this history is crucial to understanding many Americans' experience of governance in the late 20th century, people like Peter and many others. A common refrain among contemporary critics of the American child support system is that it is irrationally punitive and extractive, that it does not even effectively accomplish its stated goals of securing support for children and recoupment of welfare costs, because it prevents parents from becoming dependable earners. In particular, support orders drive up debt that disproportionately falls on poor men of color and deepens their entanglement with the carceral state. So 70% of the $115 billion currently owed in national child support debt is owed by parents with annual incomes under $10,000. Approximately 15% of all Black fathers have done jail time for failing to pay support, and half of all incarcerated men have support cases. As the sociologist Lynn Haney argues in a recent book, Prisons of Debt, the demands and discipline of child support debt often make it extremely challenging for incarcerated people to stay financially afloat upon reentry, leading many to be re-imprisoned for willful non-payment. My talk today looks at the historical roots of this seeming irrationality, focusing on the bureaucratic logics and legal structures that subtended the support system's development in late 20th century California. Since the 1970s, support enforcement agencies like Los Angeles's have not just been client-serving institutions with a limited local mandate, but the subject of deep intergovernmental concern. As state institutions whose effectiveness could almost be uniquely measured through dollars in versus dollars out, support agencies were shaped by their originary relationship with the neoliberal politics of welfare reform and enmeshed in the fiscal dynamics of federalism in ways that pushed the law they enforced in a persistently more punitive direction. Child support enforcement's prerogatives bridged traditional domains of local governance, such as family law and criminal enforcement, with that of poor relief, which was by mid-century administered by states under the heavy influence of federal dollars and guidelines. The fact that it implicated multiple scales and functions of government made support enforcement a point of emphasis in welfare reform efforts while Ronald Reagan was governor of California in the early 1970s. By that point, state and county administrators had become especially eager to defray the expenses associated with rising welfare caseloads over the course of the 1960s. While federal cash grants covered half of states' welfare payments, states had to cover about 35% of those funds and individual counties 15%. Counties also had to cover the cost of actually administering welfare programs. Playing off popular anxieties about California's rising non-marital birth rate and recent implementation of no-fault divorce, welfare reformers in the Reagan administration promoted support enforcement as an untapped opportunity to the local fiscal burden of welfare. To ease that burden, I should say. They also identified it as a way to shift authority away from social workers they framed as implementers of overly permissive federal welfare mandates that tacitly discouraged family formation. Now, one key goal of this program was to motivate district attorneys in California's 58 counties to assume broader responsibilities in collecting from non-supporting parents whose children were receiving welfare. In 1970, the California Welfare Modernization Task Force issued a report that described intransigence in DA offices and local welfare agencies as a barrier to the fiscal benefits of support enforcement. In too many California counties, child support is relegated to a low priority, the task force wrote. What is needed is a career enforcement staff that is interested in innovating and highly trained in the intricate techniques required. The non-support field is the only major area of law enforcement in which there is a direct cost benefit to the taxpayer. Instead, Reagan's Welfare Reform Coalition argued, district attorneys needed a carrot and a stick. The carrot, eventually codified in the state's 1971 Welfare Reform Act, came in the form of a new Support Enforcement Incentive Fund, which guaranteed county agencies a bonus of 37% of all money collected from non-custodial parents of children on welfare. Given the county spent about 15 cents for every dollar they collected from parents, this transformed support enforcement into a potentially profitable venture. In order to aid collections, the law also required such parents to file a complete financial statement with the county upon submission of a welfare application on behalf of their child. The law also expanded the availability of methods for garnishing wages and placing liens on property to fulfill support orders. And it established a centralized parent locator registry at the Department of Justice that provided up-to-date information on non-supporting parents to county agencies. The stick, on the other hand, came in the form of stricter timelines that DA's offices were required to follow for pursuing welfare cases, as well as annual grand jury audits of county agency performance. California's model of incentivized enforcement was an important reference point for federal policymakers in constructing the national child support system that they passed into law in 1974 via Title 4D of the Social Security Act. For example, Russell Long, the influential chair of the Senate Finance Committee and a major driving force behind the law, lauded California as the first state, quote, to offer constructive alternatives to the welfare mess and indicate a willingness to put them into effect. The new Federal Office of Child Support Enforcement, or the OCSE, was tasked with setting national standards and reviewing state plans for support enforcement. It also sought to incentivize states to ramp up collections by allowing them to keep a quarter of the support they collected, while also penalizing states without approved plans or that failed to meet certain benchmarks with the partial loss of federal welfare funds. What this meant is that state governments like California's became even more invested in the policies and performance of county child support agencies. This was especially true of Los Angeles County, which had one of the state's highest rates of welfare receipt and lowest support collection rates. In 1980, Marion Woods, the director of California's State Department of Social Services, wrote to John Vandekamp, LA County's Attorney General, to express his dismay with the county's performance. Woods noted that because California was facing a $1 billion deficit, all state revenue-producing programs, and especially the child support program, were being scrutinized for cost effectiveness. Los Angeles often determines statewide outcomes in child support collections due to its size in comparison to other counties. Woods reminded Vandekamp of this, but he also reminded him that collections in LA were down due to, quote, constraints which currently hamper your enforcement effort. He then warned that if the federal government held Los Angeles out of compliance due to poor enforcement, the state could lose 5% of its AFDC funds. Now, the specific constraint Woods had in mind was LA's policy of not enforcing so-called agreements for entry of judgment, or AEOJs, which were essentially forms that district attorneys' offices often gave to non-custodial parents on which they could stipulate to their legal parentage and a child support award without ever going to court. On the left here is an AEOJ, a sample one filled out on behalf of Snoopy from Fresno County in the 1980s. I'll go. Los Angeles County had a good reason for proceeding cautiously with AEOJs around this time. The California Supreme Court had just ruled in 1979 that they often violated supporting parents' due process rights. This was because DA's offices tended to present them to parents without notification that they constituted a waiver of their right to trial, and with the implied threat of criminal consequences if they didn't sign. But under pressure from state administrators to improve its collections, in particular from parents with children on welfare, where the state would get a cut, LA County began to enforce more AEOJs. During the 1980s, these sorts of requirements when it came to support enforcement became codified in interagency agreements and plans of cooperation between county DA's offices and welfare departments. These agreements proliferated alongside ones between counties and state agencies, as well as states and the federal OCSE. Following the passage of federal support enforcement amendments in 1984, these plans were required to assign responsibility for a host of mandatory enforcement tools, such as income tax and wage withholding, and expedited procedures for establishing paternity and support orders. These kinds of, quote, bespoke and deeply integrated administrative structures, as the legal scholar Bridget Fahey puts it in a recent article, have become central to the contemporary administrative practice of cooperative federalism. Now, beyond pointing out that support enforcement was a historical arena of state building where such administrative arrangements flourished with particular multi-level complexity, there are just a couple things I want to emphasize here. As the previous example about AAOJ suggests, these plans and agreements often sought to constrain the exercise of discretion by DA's offices and family courts, where such discretion could hinder the establishment and collection of support orders. Furthermore, as such interagency agreements became formalized over the course of the 1980s, they became sources of knowledge for a federal government increasingly dedicated to framing its policies in the austerity-inflected language of devolution, cost-effectiveness, and responsibility. In its monthly child support report, which was sent to all local support agencies, the federal OCSC often held up experimental collaborations between law enforcement and welfare agencies as the leading edge of effective enforcement policy. For example, it advocated the expanded use of FBI-style most wanted lists of non-supporting parents, as well as the use of short jail terms as quote-unquote shock detention to incentivize parental responsibility via punishment. The Government Accountability Office also emerged as an influential voice within support policymaking around this time, pushing local collaborative efforts such as reporting support debt to credit reporting agencies and expedited paternity establishment as models for efficient national governance. Federal welfare reform legislation passed in the late 1980s and the early 1990s translated such experiments into state mandates. As county administrators frequently pointed out, though, expanding and systematizing local government responsibility for enforcement did not necessarily make it easier to track down and collect from non-custodial parents. But it did mean that they had to try more methods of doing so within shorter and shorter timeframes. For example, the district attorney of Sutter County, a rural county in California, wrote to the State Department of Social Services and the OCSC in 1989 to complain that his office was being forced to spend limited county funds in order to try to meet impossible collection benchmarks. In many cases, he noted, his office's small staff was simply unable to serve parents with legal papers because they moved between addresses and jobs so frequently or took steps to avoid service. It must be remembered, he wrote, that the people whom we are trying to serve are in large part shiftless, transient, and irresponsible people who are attempting to the utmost to evade their responsibilities as parents. Large counties had other problems, often arising from the scale of the systems they were being told to impose. To put some numbers to the point, in 1986, the LA District Attorney's Office had several hundred dedicated staffers responsible for handling 765,000 support cases. Of those, 70% were categorized as inactive due to either the office's failure to locate the absent parent or the absent parent's inability to pay. All told, the office reported regular payments in only 30,000 of its cases. In 1987, faced with criticism from local activist groups, as well as state and federal administrators, the LADA's office sought to privatize its entire child support system. While it stopped short of full privatization, the county did contract out many key support functions. This included bringing in Lockheed Martin to enter court orders, process payments, and essentially act as the county's customer service agents by responding to hundreds of thousands of phone calls that the agency received each year from non-custodial parents. By the early 1990s, legislators in California started to respond to what they saw as a trend in the failures of county enforcement institutions with laws that use state power to expand the scope and teeth of child support debt. In 1991, Governor Pete Wilson signed a bill that added a 6% interest penalty every month to the total amount of support owed by any parent more than 30 days behind in payment. You can see how that would compound rather quickly. The bill also sought to strengthen enforcement, especially against self-employed parents, by preventing state agencies from issuing professional or business licenses to child support debtors. This policy soon expanded into requiring the suspension of driver's licenses, which became part of national policy as well in the 1990s. By 2002, parents in California, like Peter, whose story began this talk, were collectively on the hook for around $18 billion in support arrears, up from around $2 billion a decade prior. And a key driver of that ninefold increase was the use of interest as an enforcement tool. So in closing, I want to note that my talk today has touched on a number of historical trends commonly associated with the rise of neoliberal governance. That would be a managerial emphasis on cost effectiveness, austerity and privatization in social welfare, and a widening net of racially disparate punishment and intractable debt. I think we're used to hearing about the ideas and national policies that catalyze these phenomena, but the history of support enforcement in California highlights how local struggles to control and standardize administrative practices shaped and toughened the law of neoliberalism from the bottom up. The child support system that emerged as part of this agenda and persists today may strike us as counterproductively harsh, but to its architects and administrators, it was a perfectly rational way of enforcing their vision of responsibility on both parents like Peter and government itself. Thank you.
Thank you all for being here again. So the title of my talk is Repairing the Walls of Our Own Prison, Race, Youth, and Administration in the Juvenile Industrial Reform School. I'm thrilled to be sharing kind of a small part of what is a larger project about the construction of juvenile justice, both courts, policing, but then also these industrial reform schools that are built as schools, and how they actually function in practice is kind of the subject of my talk. And I'm going to be looking at two different institutions today, specifically Gatesville in Texas and Fort Grant in Arizona, and the intersection of Latinx youth who found themselves within these spaces. We'll see how these institutions and the policies increasingly segregated, punished, and discriminated against Latinx youth while simultaneously erasing them from the history of juvenile incarceration. So first, a small note on finding Latino youth within the juvenile justice system as a whole. This is part of why I started this project, was much of the historiography really omits the Latinx experience, or it's written off as segregated and basically it's Jim Crow experience. And especially within the Southwest, that was increasingly not the case. Some of the work later on has kind of focused on post-World War II. And so my work really wants to push that back and show that often Latinx were part of these systems from the get-go. And so part of the reason I'll be using also Latinx is finding people of Latinx heritage is kind of difficult within the literature, and that was part of my big problem in kind of doing this work, is they're always using shifting or evolving categories. In the case of Texas, it would change from year to year. Sometimes it would be Spanish-speaking white, others it would be Hispanic American, Mexican American. So I try to use Latinx to kind of encompass these evolving racial categories. And I often have to use a variety of sources to really determine where the Latinx kids are and how many there are, and this can range from published data to newspaper reports that will actually list race, institutional photographs, and then one of the pieces of evidence that I'll show often in this presentation is newsletters that the boys wrote themselves. And across the Southwest, Latinx youth are being sent to the juvenile justice system at high rates from the beginning of the century. When compared to demographic data, Arizona's Latinx population between 1910 to 1930 grew from about 24% to 24% to 26%, and within Texas, that from the same time range, it was 7% to 13%. And admission to these industrial reform schools were increasingly disproportionate to the rate of Latinx people within these states. So this is another example. This is kind of the more complete data that, and you'll see there's large gaps because I'm just unable to find the data. So putting these two in comparison, I think helps us get a better sense of just how many Latinx boys are within, and these are boys' schools. And it's upwards of 30 to sometimes 70%. And so these are incredibly Latinx spaces and really need to be told through the perspective of Latinx youth. So industrial schools in Texas are explicitly segregated. The main school for boys, Gatesville, had two separate campuses, separate schools on its campuses, one for white boys and one for black boys. Gatesville was built in 1887 to take youth out of the nearby adult prisons and place them in a facility for youth. And on paper, the school would emphasize that it was indeed a school, ordering books, hiring teachers, yet reality at Gatesville was very different. Most accounts from the school's lifetime reveal horrific abuses and that it functioned as a prison labor camp more than anything else. I began my research into this topic trying to find the Latinx youth within these facilities, and Gatesville presented a unique challenge. On paper, the school basically didn't have Latinx youth. Rather than using more or less concrete labels such as Mexican or Mexican American to categorize Latinx youth, paperwork in Texas's juvenile justice system uses a host of ever-changing phrases, from Spanish-speaking, white Spanish-speaking, Latin American, to differentiate between white youth viewed as white and Latinx, who were legally categorized as white, but by no means treated both as white. The earliest dormitory, Gatesville, was constructed in 1913. This is part of that early slides. The large two-story brick building was a simple design, aimed at meeting the needs of the newly established state school, specifically the white campus part of Gatesville. It designated the first floor for a classroom space, a small chapel for religious instruction, and in these rooms, during the week, youth attended classes on basic math, reading, writing, and Texan history. The second floor served as a dormitory designed to keep youth under the continuous fear of surveillance. This dormitory had chain link fences in place of a wall, situating youth between chains and the wall of the building on the other side, and this is where they slept. Even the windows were reinforced with chain link fences to prevent escapes. Unfortunately, it would also prevent youth from escaping in the case of a fire, since there was no safety latch, allowing youth to utilize the windows as an escape route. This surveilled space went even as far to providing the detained youth with a 24-hour guard. Guards were provided with traditional rooms for living quarters with private restrooms and had a viewing space into this long dormitory where all the boys slept. The practice of keeping these young boys in spaces that resembled cages was something that remained in use at Gatesville through the 1960s. It reinforced the idea that Gatesville administrators viewed the young prisoners as being closer to animals than human. But I was still wondering about what Latinx youth experienced within these spaces, and it was within a collection of notebooks from a Gatesville landscaper that I found several references to a Mex boys' toilet, and that's this right here. And there were volumes of the different plants, irrigation, and somehow I came across this purely by accident, and this was the first reference I actually found to segregated spaces on the campus for Latino youth. The small throwaway line among details of agriculture lined up with another throwaway reference I found by a superintendent in 1930 to a Mexican boys' dormitory, being situated in the oldest dormitory on campus, and that's this building right here. This is all the more critical when you note that the white boys were transferred to the newer dormitory after they abandoned this one. They had the latest fire safety features and indoor plumbing. While there was no evidence to suggest segregated dormitories for Latinx youth did or did not exist for the period prior to 1930, it does point to a segregated reality for Latinx boys who were written down as white on paper but treated as racialized others in practice. So I'm now taking you to Arizona and Fort Grant Industrial School. Opened in 1913 within the abandoned remains of a military outpost from the state's territorial days, Fort Grant would welcome boys and girls with no formal racial segregation. As a training school, Fort Grant aimed to provide youth with a formal education, vocational training, and extracurricular activities to transform Arizona's delinquent and wayward youth into the citizens of tomorrow. Youth would attend classes on math, reading, and writing, in addition to weekly religious instruction provided by an on-site chaplain. Additionally, youth had access to classes on journalism that led to the creation, publication, and distribution of Fort Grant's very own youth-managed newsletter, the Fort Grant Gleaner. When not attending class, Fort Grant's youth were expected to participate in farm labor, mechanical training, and a variety of sports, and this ranged from actually being part of the powerhouse to farming to picking plants. It was almost a sustainable facility. And the programs were aimed to give youth a sense of normalcy, but also skills before they would graduate, and that is the term they use, out of the detention center. And I just wanted, these are the newsletters themselves. I've kind of been looking into this production of newsletters by incarcerated children. There's a lot of historiography on adult prison writing, And there seems to be this big gap of children's prison writing. I know of one other scholar who's found something similar from a girls' school in Illinois, and so this is one of the few other references I've found to kind of children's writing. And the artwork on the front is actually done by Theo Romero, who was a 13-year-old Mexican-American boy who claims has no prior artistic, and these are woodblock carvings that he created. I think they're that one particularly talented for somebody with no artistic training. The writing in The Gleaner provides a glimpse into the life of Fort Grant for so many youth, and is one of the most fascinating parts of these newsletters is actually hearing and finding the voices of Latinx boys about their incarceration at the time of their incarceration. In a February 1932 newsletter, reporter, and they do call themselves boy reporters, Johnny Cabrera notes in his very first report for The Gleaner, quote, "We have been busy fixing frozen and broken pipes in several houses," end quote, describing the multiple problems the boys have been tasked with after a particularly harsh winter. Frozen and broken pipes across the industrial school meant no water to the dormitories or the kitchen. In the same February newsletter, another boy, Marcelo Figueiredo, describes the deteriorating kitchen causing fire hazards. Unlike Johnny, who seemed to take pride in his work, his piece goes on about how all the skills he's learning, Marcelo and his peers working the kitchen duty took a more creative approach to solving the problem of the, quote, smoking stove. Marcelo writes, quote, "When an officer catches a boy smoking, he turns in a written complaint. So we've all signed a complaint against the stove and turned it into the detail officer. And since they have changed some of the pipes, it has not been so bad, and we have not caught it smoking so often. Perhaps you are not interested in my silly chatter, but it was in my system, and I sort of had to get it off my chest." The story of Fort Grant continually falling into disrepair as administrators left the work to incarcerated boys continues throughout these early decades. And remember, they entered the school in 1913, so we're really only 20 years in. Broken fences meant the loss of farm animals, broken hoses made irrigation difficult. Even the archway welcoming the boys to Fort Grant fell down in April of 1932. And time after time, the task of rebuilding the industrial school was left to its incarcerated youth. One of the most explicit forms of racialized punishment towards Latinx youth in this space was actually the banning and punishment of Spanish speaking. This is the mess hall. In the case of Fort Grant, Spanish-speaking and bilingual youth made up between 30 to over 50% of the population at any given time between 1921 and 1960. Fort Grant officials aimed to stamp out this practice and made speaking Spanish a punishable offense. According to a 1934 report, speaking Spanish is listed with offenses such as disturbance in line when in formation and throwing rocks. In that same year, 80% of the youth at Fort Grant were Latinx. Now, what makes this policy even more racialized was the fact that documents, these newsletters, demonstrate that Spanish continued to be spoken and used within the walls of Fort Grant. Within the Gleaner in particular, when Spanish was used, it was actually almost always being used by a white reporter rather than a Latinx reporter. So when it was found used by these white boys, Spanish, when spoken by a Latinx boy, Spanish was treated as something subversive or criminal, but became somehow charming and appropriate when used by a white boy. Spanish speaking was a minor offense that could be addressed with a series of demerits that could also include having their head shaved, being forced to stand on one leg, or at attention for upwards of 6 hours. At the time of this 1934 report, Fort Grant was in the middle of one of multiple investigations that alleged the school was using, quote, medieval punishment that included beatings and solitary confinement in a room without a bathroom, running water, or bed. On top of this, the sheer overcrowding, the investigators found that the sheer overcrowding magnified the brutality of life at Fort Grant. And so it's very easy to assume that these smaller punishments were in fact not being used all the time. I think it's important to note the way that other youths attempted to fight back against the conditions of these confinements at these industrial schools. And I've described a little bit about the more creative approaches through the newsletters and these kind of using the administration against itself with the use of that, the report. But ultimately, one of the most kind of feasible ways of fighting back was escapes. Escapes happened at both Fort Grant and Gatesville. However, I was only able to find statistical data from Fort Grant, and they do really reveal some patterns. Primarily, youth escaped in pairs or groups. Of this kind of group, 30 total escapes in this year, only 5 were of youth escaping by themselves. Interestingly, though, the solo escapes had the most luck in evading authorities for a longer period of time, typically up to 2 to 5 days. The only recorded escapes for 1927 that lasted upwards of 5 days were by 2 solo escapees. Second, the escapes were overwhelmingly done by male youths, although only two girls recorded as escaping were Mexican-American girls. Fort Grant they would take the girls out by 1928, so this still includes girls in the data. Third, escapes were overwhelmingly Latinx. Youth classified as Mexican or American Mexican made up 46% of total escapees. This number could be higher, but information about 6 other youth did not reveal their racial categorization. Fourth, escapes did not last long, as I mentioned earlier. The majority were caught by the end of their second day. The position of where Fort Grant is, it's really miles and miles of farmland, and it's about a 2-hour drive to Tucson, so you can imagine there's quite nothing out there. Now, the groups that did escape tended to be racially homogenous. There was only one group to break this pattern, which was a statistically unusual group of 5 boys made up of 4 white boys and 1 Mexican. Furthering the curiosity, the 1 Mexican boy in this group was one of the 2 that had escaped twice. So I somehow believe that perhaps he had gained knowledge during his first escape and then was able to lead a second escape. And all these kind of details point to a very realistic picture of the conditions at Fort Grant and the efforts made by youth to escape those conditions. Latinx youth, regardless of gender, seemed more prone to escape attempts. Their experiences at Fort Grant criminalized basic aspects of their identity and their communities. So it would seem logical that under these circumstances, Latinx youth would look to escape as a solution to these conditions. And even in the case of the Mexican boy who escaped on his own and then again in a group, he may have been leading and organizing these escapes to the best of his ability. While punishment towards Latinx youth were shaped by ideas of Latinx youth as inherently more criminal than white youth, educational services in these carceral spaces also served a dehumanizing effect. These practices included limiting specific classes to only white youth, segregating schooling schedules within these facilities, and labeling Latinx youth as illiterate. By limiting access and labeling Latinx youth as less academically gifted, juvenile justice officials created racialized narratives of Latinx youth that affected their lives at these institutions and potentially beyond. Yet despite the efforts against and perceptions of Latinx youth, records provide concrete evidence of Latinx youth actually succeeding academically and challenging the narratives being placed upon them. The honor roll at Fort Grant, which was actually listed at the end of these newsletters, revealed that Latinx were on the threshold of being the majority of the reform school's top students and found ways to overcome the racial stereotypes and racialized treatment. These statistics challenge how Latinx youth were characterized and demonstrate that Latinx could indeed thrive in academic settings. During this period when Latinx youth made up 46 to 64% of the youth at the facility, they demonstrated actually quite great academic aptitude, and it's clear that these children should not have been listed as uneducated or illiterate. Juvenile reformatories and industrial schools in Texas and Arizona have been the subject of juvenile justice historians in recent years, as it gives us a better understanding of how these carceral spaces have moved into the borderlands and kind of into the West. Yet stories about places like Fort Grant and Gatesville are sadly incomplete without telling the history of Latinx youth, who made up significant parts of the population and often the majority from the get-go. And they were often the subject of these racialized policies and punishment that often went without formal documentation. These stories, ranging from escapes, segregated housing, and denied services, reveal that being Latinx in a juvenile detention center was an inherently racialized experience. And furthermore, the experience of them demonstrate that increased racialization by the juvenile justice system from the court into these reform schools demonstrated the increase from the court into this. These stories reveal that Latinx youth were not just a facet of these institutional histories, but rather the invisible center of them. Thank you so much.
So as I said, unfortunately, Rabia couldn't be here to comment, so we have a bit more time. I'll start us off, and then you should all chime in. Thank you for 3 really interesting papers. A question for Will to start. You have this very persuasive account of the intersection of kind of neoliberal ideas and then kind of administrative practices on the ground that take us to this child support regime that we have. Was there any kind of resistance from within the kind of administrative state apparatus that you're looking at, either on concerns of, sound injustice or just kind of economic irrationality of the whole thing? And what happened to those? How did they?
Yeah, absolutely. There was, definitely. And I think part of that has to do with just kind of the growing pains of expanding an administrative agency that quickly. And the kind of technological changes that underpinned the nature of the work that was being done. So in my research so far, I've encountered a lot of complaints by workers who were initially kind of on the social work side of things, who were then being asked to, familiarize themselves with these like very technical programs that would transmit information, from intake. Like you would take the information from a welfare application and be transmitted to a child support enforcement worker. And then they would pass it out to other agencies. So there are complaints about that, of just like the nature of the work being performed, the kind of number of caseloads that each individual worker would have. I mean, if you did the math in LA during my presentation, each worker had something like 1,500 cases assigned to them, which is not a formula for personalization or really understanding the people you're working with. And that, I think, bled into questions about the justice of what was being done. I mean, you kind of see a lot of intransigence, not only from people with kind of training in social work, but also just family court judges in enforcing or handing down these orders because they're actually often being confronted with people who are being asked to pay and seeing their individual circumstances. So, one of the things I'm tracking, and I hope it came across a little bit in the presentation, is these laws are intended to like take that decision making out of the hands of judges and workers, and basically make them do very, very specific levels of support, timelines for enforcement, and eliminating the possibility of like purging that debt. So those are the 2 areas I'd see the resistance in.
Carolyn?
I also had a question for Will. I wondered if you might broaden out your view of that, fill in some of the timeline and address whether you think there might be a counter narrative that, despite the relatively vigorous interagency enforcement that you found, that the longer view is more of the more things change, the more they stay the same. And then I have some sort of the anecdotal reasons for thinking that might be true. I'm certainly not an expert in this area, but on the front end, you're talking about sort of the progressive era beginnings of domestic relations court. My sense is that although they have this quasi-criminal jurisdiction, it's not actually all that effective, not that much more effective really than the policing of domestic violence. And then the sort of anecdotal piece is that many years ago now, when I was a law student, I was an intern for the AUSA's office in the Northern District of California. And one of my tasks, one of my fellow interns' tasks, was working on the deadbeat dad cases. And of course, we were very excited to be doing law because we were law students. But my sense is the reason that we were working on the deadbeat dad cases is that the federal prosecutors didn't especially consider them criminal cases and didn't really want to work on them. And that was, all right, I'll reveal my cards here. This was 1998-ish. So just sort of after the period you're talking about. And I'm just curious, I don't really know the timeline, but is this sort of a blip where the enforcement gets vigorous and there's this big effort, or what is sort of the pre and post story?
Yeah, so I think with the question of federal prosecution, that was relatively new at the time that you were working at that office, and that's part of an effort to respond to what is seen as kind of state and local failures to enforce, to allow for, especially with interstate cases, federal prosecution for certain levels of non-payment. So I can imagine that there was some like resistance to that among federal prosecutors. In terms of the longer story, I think, absolutely there is the use of criminal enforcement, even before the early 20th century, we have examples of this. It can be very dependent on what state and what locality you're in terms of like the level of effectiveness of that enforcement. Michigan has a especially effective child support enforcement system, like starting in the 1930s because of the way that they handle things. What I would say about it is that, maybe if your case gets to court, or if the case is handled, it might be effective. But we're talking about like a scale of an enforcement issue that persists, through the period that I'm talking about. And a lot of the efforts that I'm interested in are efforts to like fill that gap. And I would very much agree with you that there is this continuous level of failure to do that. But the mechanisms that come into play in order to address the failure of state institutions are, have ripple effects outside of, the areas that they're initially confined to. I'd love to talk more about it because I think that domestic violence and actually support are very intertwined around this time in particular.
Spencer?
I have a question for Doris about the sort of cultural violence of saying, of not using Spanish and so on. I'm curious about names. Mm-hmm. Is there an attempt to sort of impose, even at a legal level, to say rather than using a Spanish-derived name?
So it's actually interesting you mentioned that. One of the things I began noticing when I went through the newsletters and kind of figuring out who the boy reporters were, and then I would match it up with kind of the honor roll data, I actually found out that many of the boys, like Johnny Carrera, he's Juan.
Right.
He uses Johnny in his byline, and this was actually a pattern I found with many of the Latinx boys, is they would kind of use anglicized versions of their Latinx names in their bylines and how they presented themselves. So these newsletters were, I think the circulation is about 200 to 250, and I've always tried to figure like who are they sending it to, and I don't have a crystal clear answer. I know that some other prisons were actually receiving them because I found references into like one of the Oklahoma state prisons was receiving them. Some of the adult prisons in Arizona received them. Formerly incarcerated boys were on the subscription list, and then some of kind of like reformers were receiving them as well. But it's very interesting to me that the boys chose that because that's not what's listed on their honor roll name, but it is in kind of how they choose to present themselves and their like public persona. So I think the boys are definitely, like, you can see them kind of internalizing some of this. One of the other parts that I didn't get to in the presentation is also, most of the boys identify as Catholic, yet they only have a Protestant chaplain on hand. And this is true at both Fort Grant and Gatesville, as they will always keep a Protestant pastor on hand. And they claim that they will bring in a Catholic priest, for certain services. Like I think they claimed it up to like 3 times a month, but I find it hard to believe that in Tucson, of all places, they can't find a Catholic priest. Like, if you've been to Tucson, there's more Catholic churches than there are, I think, Protestants. So I suspect, although I don't have any evidence of that, is if they were to bring a Catholic priest in, they probably would have been a Spanish speaker. So they were maybe trying to limit many of the boys' access to perhaps transmit information in Spanish to others.
So this is a question for Laura. This question is sort of outside the scope of your paper, but it was stimulated by your paper and thinking about your paper in terms of whiteness literature. So you discovered, you've seen all these cases that people had put together for discrimination against Latinx students. If you looked at other ethnic groups and sort of did the same thing, groups that were only marginally white, historically, would you find similar things? I mean, that's an unfair question because that's not your paper, but I'm wondering if that provides actually, if you don't find it, that's an angle to sort of think about really that whiteness literature doesn't quite get things right.
I would think that there is a correlation to that kind of literature, particularly if you look at the history of Irish and Italian youth in the Northeast, and there are scholars who've done some of that work. And also in the West, when we look at Asian American populations, and then of course Native American boarding schools, I think that all of those communities have experienced some form of segregation or separation. I think the big question is, in the case of Mexican Americans, is this driving line between the pedagogical rationale and the racial logic that's being employed. And that's where the historiography and the case law seems to suggest, at least early, I would say before the Chicano movement, before 1970, that all of this was done for pedagogical reasons. And so challenging that is one of the tasks at hand. Like, okay, for pedagogical reasons, we could see why all kinds of groups of students would be segregated. But is that really the truth in the case of Mexican American youth?
We have time for another if, am I seeing everyone? Oh, please, Jerry.
I've got another one for Laura. I was
Okay.
wondering if you observed any differences in the case of New Mexico. I only ask because my understanding is that there are constitutional provisions in the New Mexican Constitution that gave some official status to Spanish, somewhat distinctively, I think, compared to the other southwestern states. But I was just wondering if that was a case that you have looked at.
You know, I haven't looked specifically at any New Mexican cases, and you'll notice on that list there aren't any. And I think that has to do with the legal framework, the constitutional framework of who Mexicans are in that state, in the ways that the Hispanos, especially the Hispano elite, shaped equality for themselves. The other issue, though, is that Spanish was also treated in a particular way in that state, and segregation was also used in some educational settings. So, for example, Spanish American or Hispana women who were interested in becoming teachers were sent to the Spanish American normal training school in northern New Mexico instead of being matriculated into the University of New Mexico or New Mexico State. So there were ways that Mexican Americans were still seen outside of the status quo within the school system. And that particular training school is, to me, it's significant. And Sarah Deutsch writes about this in her own work because it's one of the moments where we look at higher education and the way higher education begins to distinguish between the racialization of its various student bodies. And so why is it that Hispana girls are being sent to this training school for Spanish American girls as opposed to being sent to Arizona State Teachers College, where all students of all races, with the exception of African Americans until the late 1920s, are admitted. So you could be a Mexican American in Arizona and you would be sort of seen as a white person because you'd achieved this level of education that allowed you to matriculate to the normal school or to the college. So race is definitely a factor, and I think New Mexico is a special case because of that.